Let's see here. Yes, I did. All right. Gloria Yvette Williams. Good morning, Ms. Williams. Ma'am, you're charged with the third-degree felony of injury to a child by omission, the first-degree felony of injury to a child causing serious bodily injury, the second-degree felony of tampering with evidence when that evidence is a human corpse. I have looked at the alleged probable cause facts for these three charges, including the supplemental statement of facts, which I believe was supplied to the Public Defender's Office. I do find that there is sufficient probable cause for all three of these cases to go forward. All three cases will go to the 230th District Court. That's going to be Judge Chris Morton. Will you need a court-appointed lawyer from Judge Morton? Would you like the help today of Attorney Chris Henderson from the Public Defender's Office? Ms. Keith, on the question of bond for each of these three charges, what is the state's request?
In the first-degree felony, I am requesting a $500,000 bond. And in the injury to a child by omission and tampering with evidence cases, I'm requesting $250,000 bonds, and I am opposed to personal bonds, not necessarily because the injury cases are prohibited by this court for personal bonds to be granted, but mostly based on the horrific facts and circumstances of this case, which resulted in the death of a 7-year-old child. As is reflected in the statement of probable cause, officers were called out to a residence in Harris County on Greencrest Drive on October the 24th of this year regarding the death of the minor complainant, who is the child of this defendant. There were 3 juvenile witnesses who are also complainants in these cases. There was a 15, 10, and 7-year-old child who are witnesses to the incident. Officers arrived, spoke with the 15-year-old child, who stated that he found his younger brother, the deceased minor complainant, in a bedroom of the residence sometime around Thanksgiving of last year, 2020. He believed this defendant would call the police, told officers that she never did so, and that she then had moved out of the apartment, leaving them in the residence with his deceased younger brother without adult supervision. He stated that they had found his younger brother approximately 1 week before Thanksgiving. He also told officers that the co-defendant, who is the boyfriend of this defendant, would lock them in a bedroom and he would hear them hitting his brothers while he was in the room with them. He stated he told this defendant about the conduct, but she ignored him, said she would talk with the co-defendant, and the 15-year-old stated, quote, that never worked. Officers also spoke with the 10-year-old complaining witness, who is the complainant in the first-degree felony serious bodily injury case, who stated that he was actually in the room when the co-defendant assaulted his deceased younger brother, striking him in the face, feet, buttocks, back, his legs, and testicles with closed fists and feet. He stated that the co-defendant then laid his brother on the floor and put a cover over him, that the defendant then came in the room to check on his younger brother, saw the body under the cover. She began crying, then made him leave the room. The 10-year-old stated that the defendant and the co-defendant then began fighting because the co-defendant had killed his younger brother. He stated that the defendant then came back another day, checked on his younger brother, and found that his body, feet, and teeth had turned into a skeleton. He stated that the co-defendant would beat him as well, hitting him on his buttocks, legs, stomach, and face, and punched him in the jaw, causing his face to be swollen. He stated when the co-defendant would drink beer and alcohol, he would get very strong. The 10-year-old also stated that his younger brother was on the floor under the cover, that his body was a skeleton, and that his hair was off. Law enforcement officers on scene observed that 10-year-old child to have extensive swelling to his face and jaw when they made contact with him on October 24th. He was transported to Texas Children's Hospital, where it was discovered that he had blunt force trauma to the face, which would require surgery because medical treatment was not sought or obtained when he was injured. During a forensic interview the following day, he disclosed that the injury had occurred when the co-defendant struck him in the face approximately 3 weeks prior, and that this defendant was aware of the injury but did not seek or obtain medical aid for him. The 7-year-old child was also interviewed, who stated that he saw it when his older brother, who is now deceased, was injured. He said he saw the co-defendant punching his brother, that his brother was lying down and the co-defendant kicked him with his feet, that his brother was not moving and the co-defendant continued to kick him and stared at his younger brother as he kicked him. He stated his younger brother's eyes were black and that he stopped blinking during the assault, that they pulled back the covers and saw that he was really dead and saw roaches everywhere on him. Officers also spoke to this defendant on October the 24th, 2021, when she was interviewed, and she stated that in November of 2020, before Thanksgiving, she had gone into the bedroom where the deceased complainant and 2 other children were at. She witnessed the co-defendant punching her now deceased son. She said she stopped him from continuing to assault him, that she entered the bedroom the next morning and found him covered with a blue blanket, that she pulled back and found him to be deceased. She confronted him, the co-defendant, who stated he was sorry, that he lost it and punched him, and continued punching him until he went to sleep. The co-defendant told her that he covered him up with a blanket after he went to sleep. The defendant admitted that she knew he was deceased in November of 2020, but did not notify law enforcement at the time of his death because the co-defendant had told her not to. She was afraid that the children would be taken by Child Protective Services and that she would go to jail. Officers on scene on the 24th found the deceased and badly decomposed body of the 9-year-old complainant discovered under a blanket in the bedroom. An autopsy was conducted, and the cause of death was found to be a homicide due to homicidal violence with blunt force injury. I'm requesting those bond amounts, and I'm opposed to lower bonds, as I do have concerns for the safety and protection of these surviving complainants, and do not believe that this defendant should be permitted to have any contact with these children or any children in the community. I am requesting a protective order for the surviving children, and as well as urging the state's motion for bond conditions. I believe there was one filed in every case, so the first degree, that she have no contact of any kind with any of these children or the co-defendant, that she be ordered to surrender any travel documentation in the form of a passport, visa, or other travel documents, that she not possess or use any firearms, ammunition, or other weapons, or use, possess, or consume any alcohol, controlled substances, and that she be drug tested, that she be subject to an electronic monitor with a curfew of house arrest, that she have no contact of any kind with any child under the age of 17, or participate or supervise any activities involving children under the age of 17.
All right, very well. Mr. Henderson.
Judge requesting a $200,000 bond 24 years old and she's always lived in the Houston area. She won't go anywhere else while on bond and can abide by bond conditions. She's going through a period of unemployment and has limited financial means. But prior to the period of unemployment, she worked at a Macy's for 1 year, which does speak to her ability to turn up to court, that she held that job for that period of time. She's familiar with public transit in Houston and can use that to make her experiences. She can abide by any no contact provision with any children under the age of 17. The children, she can live in a separate residence from the children while they're in CPS custody. She can abide by bond conditions. So requesting a $200,000 bond and $50,000 bond.
All right, thank you, Mr. Henderson.
And just for clarification, the protective order is being requested in the first degree.
1745064.
Correct.
All right, and the court will issue the MOAB under that order. Ms. Williams, I'm going to set bond for you on the injury to a child case. I'll set that bond in the amount of $350,000. On the tampering with evidence charge, I'm going to set that bond in the amount of $300,000. And on the injury by omission, I'll set that bond in the amount of $250,000. I am going to issue an order of emergency protection. It's going to require you to have no contact with the minor children be identified in the MOAB by their initials because they are minors. In addition, I am going to issue a bond supervision order. That bond supervision order is going to require you to have no contact with those children. You may not use, possess, or consume any illegal drugs or alcohol if you make bond. You may not use or possess any firearms or other weapons. I do want you to get a GPS device on within a day of your release. There will be a 24-hour curfew. You are prohibited from having any unsupervised contact with any person under the age of 17 years. You are not to supervise, participate, or attend any event where children under the age of 17 years are participants, and you must remain 500 feet away from any school, park, playground, or other location where children regularly gather. And that is, that bond supervision order will be in the first degree case, same as the order of protection. Ms. Williams, are you a United States citizen? All right, if you'd have a seat for just a moment, I'll bring you back up. We'll talk more about the order of protection.